Good afternoon, and welcome to our kickoff event for New York Civic Learning Week, The Right to Civic Education, a conversation with U.S. District Judge William E. Smith, hosted by Democracy Ready New York at the Center for Educational Equity at Teachers College, Columbia University. I'm Nan Mead, the Center's Director of Outreach and Communications. We'll begin the program shortly, but first, a few housekeeping items. Today's event is being recorded, and all attendees will receive a copy of the recording. The chat feature is available throughout the session. You may use it for your comments. Please use the Q&A feature to pose your questions. If you're comfortable, please include your name and affiliation. After the main discussion, we'll have a Q&A session. And now I'd like to introduce Andrew E. Brennan, who will give opening remarks. Andrew is the co-founder and board chair of the Kentucky Student Voice team. He is also a second-year student at Columbia Law School. Andrew.
Thank you very much, and good afternoon, everyone. It's an honor to welcome you all here to this important discussion about the right to civics education. This conversation brings together two individuals who have been at the center of a persistent legal question, one that goes to the heart of our democracy. What responsibility do our schools have in preparing young people to be active, informed citizens? In his decision in ACV Raimondo, Judge Smith wrote, "This case represents a cry for help from a generation of young people who are destined to inherit a country which we, the generation currently in charge, are not stewarding well. What these young people seem to recognize is that American democracy is in peril. We would do well to pay attention to their plea." Though Judge Smith ultimately ruled that the US Constitution does not guarantee a federal right to civics education, his decision underscored the urgency of the issue. He noted the shortcomings in our national education priorities, writing that the plaintiffs should be commended for bringing this case. It highlights a deep flaw in our national education priorities and policies. Hopefully, others who have the power to address this need will respond appropriately. For many of us, those words were not just a reflection, but a call to action. At the Kentucky Student Voice team, an organization I helped co-found, we took that call seriously. We recognize that while the US Constitution may not explicitly guarantee civics education, the Kentucky State Constitution does. Section 183 of our state's constitution mandates an efficient system of common schools throughout the state. That language, as interpreted by our Supreme Court, establishes a right to an education that includes sufficient understanding of governmental processes to enable the students to understand issues that affect his or her community, state, and nation. Our schools are supposed to be incubators for our democracy. And yet, Kentucky is one of just 11 states with no civics course requirement. Deprioritizing civics has predictable results. Half of Kentucky students cannot name a single local elected official or the three branches of government. So, inspired in part by Judge Smith's words, we filed a lawsuit against the Commonwealth of Kentucky for failing to uphold our constitutional right to a quality education. As you can probably tell, I'm more than a little excited about this conversation. I hope that all of you listening this afternoon will be as inspired as we were, and that you'll consider what actions you can take in your own communities to strengthen civics education and, by extension, our democracy. So with that, I'd like to introduce the two individuals who will be leading this conversation. Michael Rebell is a professor and the executive director of the Center for Educational Equity at Teachers College, Columbia University. He's also the co-founder, the co-convener of the Democracy Ready New York Coalition. He was the lead counsel for the plaintiffs in Cook v. Raimondo, the case I mentioned earlier. And he's currently the co-counsel for plaintiffs in the pending Kentucky litigation, Kentucky Student Voice Team v. the Commonwealth. And Judge William E. Smith was a private practice attorney and law professor before being nominated in 2002 by President George W. Bush to a seat on the United States District Court for the District of Rhode Island, where he has served for the past 23 years. Judge Smith also served as chief judge of that court from 2013 until 2019. Please welcome me and join me in welcoming both of these two individuals.
Okay, thanks very much, Andrew, and thank you very much, Judge Smith, for your willingness to engage in this conversation. As Andrew indicated, a number of years ago, I was counsel for a group of students in Rhode Island who felt that their schools were not adequately preparing them to become capable citizens, able to sustain our democracy. We brought the case in the Rhode Island Federal District Court, and Judge Smith was the judge who was assigned to handle the case. And as Andrew also indicated, Judge Smith, after much deliberation, we'll get into some of what went on behind that deliberation, but he ultimately ruled against us. Nevertheless, he wrote a really scholarly, I would say, heartfelt 50-page decision explaining the reasons for his decision and the importance that he felt that the subject matter that the students had brought to his attention really merited. So this is a very unusual circumstance, this conversation we're having today, where a judge who ruled against the plaintiffs is being asked by the attorney he ruled against to explain some of the reasons for that decision, and he is willing to do so. But one of the reasons Judge Smith has agreed to enter into this conversation, and he's actually had several other public conversations with me in the past, is that despite ruling against me and my clients, he's become a very forthright advocate for improving the public education in civics that our students are receiving both in Rhode Island and throughout the country. So I think all of us are going to be very interested to hear Judge Smith's perceptions on this issue. So let me begin, Judge, by asking you if you might explain. I know the technical legal reasons why you ruled against us in this case, but for our broader audience, in kind of general layman's term, can you explain why, despite your feeling that civic education is very important, you ruled that there was no relief for us under the United States Constitution?
Sure. Well, thanks, Michael, and it's really nice to be here. And let me just take a minute to thank Andrew for those comments, and really you and Andrew and others, because one of the things that's sort of remarkable about this conversation and the ones we've had before this, but generally we sort of, as judges, we sort of toil in the fields and work on things and write our decisions, and they just kind of go off into the ether, and we don't hear much about them. For some reason, this decision is kind of filtered out there a little bit, maybe due to your efforts in part, and it's particularly exhilarating, I guess, to hear Andrew talk about the initiatives that he's spearheading in Kentucky, and how some of the language in the decision might have been motivating for him and for his colleagues. So that's gratifying, because as I know you're going to get into in your questions, that opinion took a lot of work and a lot of study on my part, to get to the point where I could say all the things that I wanted to say in it. So your question is, why did I have to rule against you and your clients on the fundamental claim that you were bringing, which was a claim to a right to civics education under the Constitution? And I guess implicit in that is, why did it, take so many pages to sort of explain that? And as I said in the opinion, on the face of it, the reason seemed sort of obvious under the case law, but I wanted to explain the history. This is one of the things I wanted to do, was to explain the history of how we got to the decision, how the Supreme Court got to the decision in Rodriguez, which really controlled. And so the short answer to why did I have to rule against the plaintiffs is that we're bound, regardless of how we may personally feel about the issue in front of us, we're bound to follow the law. And the law is, what's in the Constitution, what's in the statutes the Congress has passed, and what's in the decisions of the Supreme Court and courts of appeals in our circuit that expound on those things, and we're bound to follow them whether we agree with it or not. And what I ultimately concluded was that the holding of Rodriguez, which is the seminal case that gets most of the attention, the holding of Rodriguez was such that I couldn't find any way around the holding that there was no fundamental right to education in the implicit in the U.S. Constitution. But I really did feel like it deserved a lot of explication so that people could understand the road to Rodriguez, if you will, and could also understand some of the other things that the Supreme Court had said both before in Brown and after in some other important cases, and particularly in the Plyer case and others. So so I think the holding of Rodriguez was binding on me. I don't think it created the little crack in the door that you wanted to drive the truck through. I couldn't let you do that, but I did want to explain the why, and I wanted to get into the policy issues behind it as well. And then, as I think you're going to get into, the case itself was sort of a civic education on its own.
Okay, well, thank you, Judge. By the way, I see you're not talking to us from your chambers, but you're in a room that has, and if I can see it correctly, a picture of George Washington and Martha Washington behind you. So where are you speaking to us from?
I'm in Washington, actually, and at a hotel that's named for George Washington. So there's pictures of him everywhere, and Martha. And I'm here for some meetings, actually at the Supreme Court tomorrow, as part of what's called the Judicial Conference, which is the governing body of the courts. The administrative governing body sort of acts as a board of directors chaired by the Chief Justice. So I'm here this evening for that, and meetings all day tomorrow.
Well, that response leads me to ask you a very specific question. At the end of your 50 page decision, I think Andrew may have read part of this, but I'm going to quote precisely what you said. Quote, "The court cannot provide the remedy plaintiffs seek, but in denying that relief, the court adds its voice to plaintiffs in calling attention to their plea. Hopefully, others who have the power to address this need will respond appropriately." Now, I've wondered for the last few years who those others that you were hoping would respond appropriately would be. And at times I said, well, he's talking to the governor and legislature in Rhode Island. Other times I said, well, since he said this Rodriguez case was so binding, maybe he's talking to the Supreme Court to reconsider the Rodriguez case. And now that you're telling me that you're going to be meeting with the Chief Justice tomorrow, You think you might bring up the Rodriguez case and ask him to reconsider it?
Well, our conversations stick to administrative matters. There is a lot of other stuff going on, as I'm sure you've noticed. Who are the others? I think it's all of those. It's all of those people. So in an immediate sense, it's the legislature of Rhode Island, the governor of Rhode Island, because the case was a Rhode Island case brought by Rhode Island students about the state of Rhode Island education. It's certainly that. But as you know, in the opinion, I wrote a lot about the role of state legislatures and state courts in particular, and the states have been really the leaders in both adopting the right to the right to education in their state constitutions and statutory law, and also state Supreme Courts have been on the front edge of finding and fleshing out what those the contours of that right. So in a way, the decision was also an encouragement to you and Andrew and others to pursue these actions in the state courts, where I thought the reception might be better. But it was also an effort to speak to a degree to the national legislature, to Congress, and to the ultimately not speak directly me to them, but through you, through the process of litigation, ultimately to the Supreme Court. There's a lot in the opinion that tries to explain how we could get from the decision in Brown in the 1950s to the decision in Rodriguez. And I tried to explain in there that it really had to do with the change in the court, because the litigation that had been brought post Brown and before Rodriguez was all trending in the direction that you wanted to go, in favor of a finding of an implicit right to education. But then the court changed under Richard Nixon, dramatically changed. And so you had a very different court deciding Rodriguez than you had deciding Brown. And the point I was trying to make is that, the pendulum swings back and forth. The court changes over time. And we see that in all sorts of areas of the law, but this is just a good example of how that influences public policy, how those changes in the composition of the court influence public policy. And ultimately, who is on the Supreme Court gets back to who the people elect as president. And so that's what I meant by the case being a civics education in itself. That's part of what I meant, because if the students could understand how we got from Brown to Rodriguez, and what were the political events and the chain of events that resulted in that, I think they would understand better how the law is made and how it evolves through time.
Well, by the way, Judge, when you mentioned that you saw this as an occasion for a civics lesson, I remember you actually used that phrase, civic lesson, at the beginning of the oral argument we had in the case. We did have all 14 of our Rhode Island plaintiffs attending that session, and they brought a lot of their classmates and others interested. So I think we had 40 or 50 students in the courtroom. And I remember when you walked in, you gave them all a smile and a welcome. And you said, you're all going to have a great civics lesson today. And you actually gave us a lot of time for that argument. Normally, my experience has been in a case like this, on a motion to dismiss, the lawyers would have 20 or 30 minutes of oral argument. You gave us well over an hour. Was that consciously done because you wanted to deliver a civics lesson?
Yeah, It was. I wanted the students to see, I wanted the students to see that their case was getting a real hearing in court. And I wanted them to see what it was like for an advocate to get up in front of a judge and advocate for their position and get asked questions and have to respond to those questions, and the sort of the back and forth that goes on in the courtroom. So I thought that might be not just interesting for them, but I thought it really might be kind of educational to understand that, these things aren't just, they're not cut and dried, and we don't, people aren't just mailing it in. I mean, these things are really seriously debated. And I thought they'd enjoy it. I thought they'd get something out of it. And so I did take a little extra time to sort of, really flesh it out and have you flesh it out.
Actually, I don't know that I've ever shared this with you, but some of those students really got motivated to become much more active just from that argument. One girl afterwards, when we had a kind of a pizza party and a debriefing afterwards to get their reactions, she was so shocked that the assistant attorney general stood up there and said, students don't have any rights under the federal Constitution because of the Rodriguez case you mentioned. And she said, if that's what that guy thinks about student rights, I'm definitely going to vote him out of office. So that was at least one kind of motivation.
Yeah.
I hope that individual doesn't feel bad about that. He was doing his job. I know that. And we all have to back our government employees these days who are all doing their best, I'm sure. But going on with the question about the civics lesson, after we had the oral argument, judges usually take, in my experience, 2 or 3 months to issue a decision in a case like this on a motion to dismiss. You took well over a year, and at times it was frustrating for us. What's taking so long? What's that judge doing all this time? But when I saw the product, it was really an incredible, one of the best decisions I've ever seen, quite frankly, because you not only understood all the legal arguments we were making, you obviously had read our briefs, and they were lengthy, and we got extra pages, and you read all of them and digested them. But you did original research. I clearly understood that. All kinds of references to the literature of the day, to historical literature. I guess you've already told us what motivated you to do this, but what was your process in doing all of this extra research to really dig into the history of civic education and its importance?
Well, the case kind of landed at a very fortuitous moment for me personally, because I was already sort of concerned, I guess, about some of the things that I was seeing in the the political and cultural world that we were living in. And this is in 2020, and it seems almost quaint now, but at the time it was concerning, and I had begun doing some of my own reading in that space. And then the case came along, and it just seemed to me that this case really spoke to some of the same issues that I was very very interested in sort of reading about and studying about the state of our democracy and what was happening, and the degradation of the sort of norms of political behavior. It was just a very different time in 2020 than it was in the sort of the political world that I had kind of grown up in the 1970s and the 1980s. When I first came to Washington to go to college, I worked in the U.S. Senate, and it was at a time when the Senate was a very engaged institution. It was doing lots of really terrific things in the wake of the, what had been going on in the 60s and the early 70s. It was the post-Watergate world, and then, in my early practice of law in Rhode Island, I represented a number of public institutions, cities, and I represented the governor and the courts and others. And so it just seemed to me that what was happening was very contrary to the way that we should be functioning as a government. So I was doing, as I always do when I get worried about something or I'm thinking about something, I start reading a lot. So I had been reading a lot about this, and then your case came along, and as I said, that was kind of a perfect marriage. So I knew when I dug into the case and was this was an opportunity to say something generally about the state of what was happening in the country, but to also say something about the issue of civic education, that the two were so integrally related. But it was clear to me that this was something I really had to do myself. Normally in my chambers, we have 3 law clerks who are working hard on, we have, hundreds of cases, and we take the cases and write opinions. Usually it's the law clerks that put together the drafts, and then I'm more of an editor than I am a writer with those opinions. But with this case, what I wanted to say, I had to say it myself because there was so much involved with it that dealt with my own feelings about things and my own reading. And I also wanted to dig deep on some of the history that sort of explained, as I said earlier, where the Rodriguez case came from. So I just dug in and had to do all that reading and do all that writing, and then so it just took a lot. It took a lot longer. And a lot of the sources that you see in the opinion are not things that you typically would see in a judicial opinion. There's a lot of references to and quotations from books about history and government and politics, law review articles. I think there's even a reference to the musical Hamilton in there. In speaking about George Washington's farewell address. So that was something I just had to do myself, and unfortunately it took a little longer than usual, but hopefully the work product or the ultimate product was worth the wait.
Well, I wouldn't say it was unfortunate. No, we were a little bit impatient, but the product was well worth the wait. So thank you. Speaking about that opinion, it's been my experience. I've heard from a number of social studies teachers around the country over the last few years that they've found this decision very useful, very inspiring and all. Did you ever think that this legal document you were writing would actually become a reference source for social studies teachers throughout the country?
No, I really didn't. I'm really gratified to hear that. In looking back on it, I think one of the things that it does kind of nicely is it sort of brings together a lot of material and resources in kind of a theme. So it instead of having to go to the original books, it gives you a lot to work from within the text. I remember getting I had sent the opinion out, since you mentioned that, I sent the opinion out to the members of our congressional delegation in Rhode Island. And I remember getting a nice note back from one of the senators, which was it was kind of a funny note because he said, well, I got your opinion and I started reading it, and as I read it, I was throwing the pages of it into the garbage can. And then after I got to about page 25, I decided I better go get those pages out of the garbage can. And so he went and retrieved them so he could keep it around. So, so I don't know. There's some, maybe it's a useful compilation of a lot of sources that could be used for both teaching and speeches and whatever.
Okay. Well, I want to go back to the decision and quote one other thing that you mentioned there. You referred to how, quote, concerned members of the judiciary are about the erosion of civic values and norms. And you actually referred at that time to a year-end report that Chief Justice Roberts had written around the time that you were composing this decision. And he had written on the importance of courts becoming involved in preparing young people for civic preparation, for civic participation. So I'm wondering now, how do you think courts and judges can best become engaged in helping young people become capable citizens?
I think first and foremost, judges can be involved in that by modeling good civic behavior and by modeling the kinds of values and norms that we're sworn to uphold when we take the oath of office in making the decisions that we make, adhering to the rule of law, staying in our lane, regardless of what we think the our policy outcome should be. We follow the law, and I actually think the moment that we're in right now is an extremely good example of judges performing their constitutional role and doing it in a really sort of dignified and professional way. I mean, and we can get into this more later if you want, but the what's going on with the new administration and the issuance of over 100 executive orders, and so many of those being challenged in courts, and judges sort of stepping up and responding very quickly, writing really good opinions, explaining their reasoning and their work. I think it's a great moment for judges modeling excellent civic behavior, if you will, and it is a civic an education in civics just to see what's going on in this moment. So that's always first and foremost how judges can participate in the education of the public and education of children. It's just by doing our jobs. A second way that I think we do that, and unfortunately this particular way is kind of going by the wayside a bit, but that's in administering jury trials. The jury trial is, embedded in our Constitution. It's the purest form of democracy that we have, and I've tried probably close to 100 jury trials over my career. I meet with all the jurors after the trials, and what do I hear from them over and over and over again is that serving on a jury was the best civic education that they'd ever had. None of them want to do it when they're called, but after they get done serving on the jury, they can't talk enough about what a great experience it was. And a lot of them are teachers. And so the teachers would say, I learned so much that I'm going to take back to my classroom. I'm so glad that I did this. But unfortunately, we have fewer and fewer jury trials. So that opportunity to sort of engage with the public and educate folks on our democracy is really kind of going by the wayside. Then the third way, and this is what one of the things that the Chief Justice was talking about in his 2019 year-end statement, was courts becoming a kind of a incubator for civic education, both in the physical space of the courthouse. That's happening in a number of courthouses around the country. One of the best ones is there, right where you are in New York, the federal courthouse there, and that was done by the late Judge Katzman, who was the chief judge of the Second Circuit Court of Appeals, but also in other courthouses around the country, Minnesota and up in Boston. There are some terrific civic education centers being located at the courthouse. And then there are virtual efforts like the Justice Sandra Day O'Connor's iCivics program. And judges can just, if we can be out there and be a part of these conversations like what we're doing today, speaking a bit about the importance of rule of law and the importance of these norms that we work with and live by. I think all of that is helpful, but we can't, we're just one small piece of the puzzle. There have to be many other organizations that are engaged in this civic education project, I think, for it to be ultimately successful. But it's really encouraging to see programs like this and other kinds of educational programs that are happening. I think there is a sort of a groundswell of understanding in the country that we're in a perilous moment, and we really need to do a lot more in terms of this civic education project if we're gonna navigate our way through these troubled times.
Well, I'd like to hone in a little more on these comments you've made about these troubled times. And again, I go back to your decision because there's so much there. But one of the things you wrote was that, quote, scholars and commentators have warned of the impending threats to democracy in the United States and around the world. And you cited in particular Stephen Levitsky and Daniel Ziblatt's book about how democracies die, and their emphasis on the, quote, guardrails of democracy. These rules of the game are not written into our Constitution, but are the unwritten, universally understood norms of behavior that allow us to govern and to be governed. And you further stated it is both these hallmarks of democracy and concomitant democratic norms that, in effect, plaintiffs here suggest are missing from the civics education of our young people. And many people would say that these guardrails of democracy are under greater challenge right now than they were 5 years ago when you wrote those words. Turning to the other people who are in this business of teaching youngsters about civic values and constitutional values, can you give any advice to our teachers who are in the classroom about how they can relate to young people the importance of these guardrails of democracy that are so much being challenged today, and what young people have to do to sustain our democracy?
I'll try. And it's important. I want to emphasize that in any comments that I make, I am not commenting on the substance of any particular case or litigation that's ongoing and, in any court, including my own court. And that's not in any way what I intend to do. I'm really, when I make the comments I'm making here, I'm really seeking to emphasize sort of the kind of the moment that we're in from a sort of a political and structural point of view, to just try to understand it, and then and how it how it may be that we should deal with it however we deal with it. But I guess the advice I would give to teachers is to really try to understand the present moment as a real teachable moment. And I think it's really unlike anything that we've seen in the country's history. And what I mean by that is you have an administration that is, and I'm not saying anything that's not really publicly stated by the administration, that they are moving with a pace, a furious pace that's really unprecedented in history, and with a theory of governance that has been really pretty well spelled out in lots of academic work that's been done prior to the administration coming into power, and they are utilizing executive power in maybe a more aggressive fashion than any other previous administration. They've issued over 100 executive orders to do all sorts of different things. And at the same time, we have a Congress that just doesn't seem to be responding to that in any kind of the kind of oversight, with the sort of oversight and response that we used to expect of Congress in decades past. So the Congress is much more placid. The executive is much more aggressive. And so a lot has fallen to the judiciary through the cases that have been brought to sort of challenge what the executive is doing. And as a result, there have been dozens and dozens of injunctions issued by district court judges, and some of those are now percolating up to the courts of appeals, and some of them will eventually get up to the Supreme Court. And so you have this kind of governance by executive order and judicial injunction, as opposed to governance by the usual, what we have thought of as the usual course for over 200 years, which is the Congress passes laws, and then the executive implements those laws, and then challenges occur to kind of fill in the gaps along the way. And occasionally you get a kind of tectonic shift by virtue of a litigation, as we did in Brown and Roe v. Wade, and then going the other way in Dobbs. But now we don't have that. We have this very different structural setup of executive order and judicial injunction. Now, we've never had that before. And there's lots of talk, how long can this go on? What's the breaking point? I mean, these are things we just don't know. So we're at this moment in time in our country's history in terms of the structure of the way our government is functioning that's never happened before. That's a real teaching moment for teachers. If they can articulate to students that you are living in a historically unique and really important moment in the country's history, that's kind of exciting. I mean, terrifying for some and exciting for others, whatever their points of view might be. But it's really kind of an amazing time to be growing up in. And so that's what I would suggest to teachers, is try to grasp the uniqueness of this situation and convey that to the students and see if that generates, some excitement.
Okay, I just have one more question, then I'd like to turn to give an opportunity to those who have been watching and listening to ask their questions. But one of the other phrases that caught my eye in your decision was that you thought it important that the schools teach our young people, quote, the spirit of what it is to be an American and even what America means. So maybe this is putting you on the spot, but I'm wondering, what is your opinion of what America means and what it means to be an American that you might want to convey to the young people who are listening to this?
Well, I guess I'll start in reverse order. What it means to be an American, what I was trying to say in that is that if we want to keep the country, if we want to keep this country and keep our democracy we need to embrace the participation in it, and we can't just expect that it will go on forever all by itself. That we have to work for it, whatever your political viewpoint may be. Keeping our democracy takes work, and so when I talk about what it means to be an American, that is really kind of what I'm driving at, is that we need to all figure out what our role is and to really engage. And that in turn converts to what does America mean? And I think there's a lot of different viewpoints about what America means, and what America means internally in the country. What are your priorities? What is it that you care about? But what does it mean to be America in the world? And that again is a teaching moment. I mean, you can have a vigorous discussion, I would think, about what the role of America should be in the world with respect to the conflict in Ukraine. You could have it with respect to the work that gets done by USAID, and juxtapose the vision of John F. Kennedy and the creation of USAID with the vision of the current administration and pretty much shutting it down. So there are a lot of different views about what it means to be America in the world. And I just think it's a good opportunity for us to be having that conversation.
Wow, that's great. Okay, well, Judge, now I'd like to give an opportunity to some of our young people to ask what questions are on their minds. And I'd first like to talk to one of the people was actually one of our plaintiffs in the Rhode Island case, Nancy Zhang, who has since graduated and still pursuing higher ed, but she's also working as a program manager at ARISE, the Alliance for Rhode Island Southeast Asians for Education. So Nancy, are you with us? And is there a question you'd like to ask the judge? Nancy? Here she is. Okay. Hi.
Yes. Hello, everyone. Nice to be able to share space with you all. And just a question for Judge Smith. In your entire career, have you witnessed young people showing up to a hearing or even being plaintiffs on a case? And how did it impact you when you saw the young people show up in person and seeing even now the fight is continuing?
Well, I am lucky to have students come into the courtroom periodically over the years, but I would have to say that in terms of a group of young people and students advocating for something, this is really the kind of the first time I've seen that. And it was different in that respect. Usually the students who are there are sort of observing whatever happens to be going on that day. But you and your colleagues, you were deeply invested in what was happening. So you were the plaintiffs. So you felt it much more acutely. And how has it affected me? Well, as I think I said at the beginning, it really gave me an opportunity with a kind of focus that I needed to dig deeply on the subject, but and really got me thinking a lot more about the role of the schools and just civic education in general. So, and it continues. I mean, I'm having a meeting a day after tomorrow with a former law clerk who's a practicing lawyer in Rhode Island, and they want to talk about setting up a nonprofit for the purpose of civic education. And they want me to be involved in that. And so, I think that I think it just that kind of thing just continues to, kind of be the snowball rolling down the hill.
Okay, so now I'd like to turn to one of the students in our current case in Kentucky, Abby Ladwig. Abby, are you with us? And Abby, we just filed our case in Kentucky 2 months ago, and we've actually got a hearing before the court coming up in May. So Abby, what would you like to ask of Judge Smith or related to the case that you're involved in?
So I just understanding how your case ended up and how it's very similar to the case that I'm involved in right now. Do you have any recommendations for how we should proceed with our case, as we have just received notice of like they want to dismiss our case? And I understand that this is kind of something similar that happened with your case as well. So do you have any recommendations for us here in Kentucky?
Well, I can't practice law, and I can't give advice to you on how to process the case. But what I will say is read that decision and give it to your lawyers, because that's one thing judges can do is bring stuff together and express views about the issue as I did there, and there's a lot in there. So the best I can do is to say good luck, and make sure your lawyers have a copy of that decision, and then they can follow the threads.
Okay, thanks very much, Abby. Now I've got before me a number of questions from other people. We don't have the means to get all of them face to face like this, but I'm going to read some of the major questions that have come in. First one is from a former social studies teacher in Rhode Island who mentioned Sandra Day O'Connor, our former Justice of the Supreme Court. And this person says Sandra Day O'Connor considered iCivics, the civics organization that she founded, one of her greatest achievements. Why is her example not more celebrated and carried on by other leaders in our judiciaries and legislatures?
Yeah, I think, I know that Sandra Day O'Connor felt, especially in her later years, she felt really deeply about civics education, and she wrote a book before, as she was maybe in the early years of her retirement, about the Constitution. It was a very accessible, easy to read, layperson could read it and understand a lot more about how the Constitution functioned. So I think this was something, I think she cared about it all through her career, but in her retirement, it really became kind of the thing she wanted to focus on, and culminated in the founding of the iCivics program. And I think the answer to your question, Michael, is that judges are really busy with all the, and Supreme Court justices are really busy with just all the cases that we have to decide. And I think with Sandra Day O'Connor, it was sort of, after she had the time to slow down and really kind of think about her life's work and think about the Constitution and young people, that she really thought, well, this is the future of the country. It's in what we pass on to our young people. And but some judges are, Judge Katzman, who's unfortunately passed away, but he started pursuing that program there in New York while he was chief judge. That was his top priority, was the creation of that Civic Education Center at the courthouse. So I think it's really I think it's really a question of just time and energy but I'll tell you, I know from talking to colleagues that judges all over think a lot about this issue and recognize the importance of it. But we're not typically, we're not educators. We can do what we can do. Back to the question that you asked earlier, we try to model it. We could be part of the education, but really, we're kind of on the periphery, I guess. But I think a lot of us would like to do more. Yeah.
Okay, well, thank you. And by the way, Judge, I don't know if you're aware of this, but Justice Sotomayor has taken over as president of iCivics now that Sandra Day O'Connor is no longer fulfilling that role. So it's great that other justices of the Supreme Court are standing up and speaking out on these issues, and it's great that judges like you throughout the system are. One of the questions that came through here was actually to me. It said, what argument for the right to civic education did you make in the case in front of Judge Smith? Well, actually, the judge actually alluded to it, that he said there was a crack, and that I appreciated your saying that we had a reasonable basis for at least bringing this case. It wasn't totally out in the extreme theoretical areas. We were building on the dissent of Justice Thurgood Marshall in that Rodriguez case that the judge mentioned. That was a close 5-4 decision, and Justice Marshall, joined by 2 other justices, had said, even if there's no right to education under the federal Constitution, which is what the majority had held, the Constitution does emphasize freedom of expression in the First Amendment. It emphasizes the right to vote in the 15th Amendment. And according to Justice Marshall, to exercise those important rights, one had to have some basic education. And the majority was actually troubled by that. And they picked that up and said that even if there was a need for such a basic education, the plaintiffs in that case hadn't brought up evidence that they hadn't gotten it. So we went to Judge Smith and we said, well, if the plaintiffs in that long ago Rodriguez case hadn't given evidence about the deficiencies in their civic education, our plaintiffs in Rhode Island were prepared to present that to the judge. So that was the basic argument we made. It was a little bit of an opening, but as Judge Smith said, he acknowledged there was at least a crack in the structure of Rodriguez, but he didn't think it was enough for us to, I think you used the word, drive a truck through. So using that dissent 60 years later to make a big dent in Rodriguez, I guess, would have called for a major overhaul. I don't ask you to comment any further on that, Judge. You wrote many pieces on it with a lot of very deep legal citations. But if you'd like to say something, I just wanted to answer that.
Thank you. I think you said it well.
Okay, thank you. Now, here's a very pointed question, and I think this kind of thing is on people's minds. So if you'd like to react to it, fine. If you think it's too political, I understand that too. But this question was, what if the executive branch decides to turn off the lights, so to speak, to influence the court's adverse decisions? What could the court system do?
So there's a lot of talk about these what ifs. What if the executive branch were to refuse to follow an order of the court in one of these injunctions, or ultimately the order or decision of the Supreme Court in a case that works its way up to the Supreme Court, or the business of filing resolutions of impeachment against judges who have ruled adversely to the administration, or as this question asks, shutting off the lights, or selling the courthouses, or not not funding the courts through the appropriations. Obviously, we are a third branch of government, but we don't appropriate. Well, we can't raise funds, and we don't have the army to execute our orders. So there's a lot of talk about that, and most of that is really uncharted territory. Some of it, I think, when it comes to resolutions of impeachment, that there's no basis for that as a response to a decision that you disagree with. The appropriate response is to appeal it and take it to the next highest court, and ultimately take it to the Supreme Court if you disagree with what these judges have been doing. So I think these impeachment resolutions are completely baseless. I don't think they will go anywhere, but they certainly are a concern to the judges that have had them filed against them, and they are really kind of a form of harassment, sort of similar to the harassment that the judges are receiving in the threatening letters and emails and phone calls that we get. We don't talk a lot about that, but there's a whole level of really sort of a really ugly side that happens out there. And but it really, to my mind, none of this affects judges in sort of just doing our job. We just go forward and we do our job. So I don't know what would happen. I hope we never get to the point where Congress or the administration feels that they should either defy or shut down a co-equal branch of government. That would be a true constitutional crisis. We've never had that in this country, and I don't believe we'll get to that point. I think maybe I'm just eternally optimistic, but I think it's more than that. I think there's a speaker I heard the other day said, I think we all would do well to temper our outrage on one hand, temper our enthusiasm on the other hand, depending on which side you're on. And I think everybody needs to just, we take things one step at a time, and we maintain our confidence that our Constitution will hold.
Okay, well, thank you, Judge. I notice we're a couple of minutes past 5, but there still are a number of questions that people have been interested in, and Judge Smith indicated that he can stick with us a little bit longer. So I'm going to ask him a few more questions. Those of you who have to leave at this time, we understand that. But those of you who can stay, I think you'll find these questions and the judge's answers to be illuminating. And this is going to be recorded. So those of you who have to leave, if you want to check them out, you'll get a copy of the recording shortly. Kind of following up on the last question, another viewer of ours asked the following: with many of the rights of students currently under threat, like peaceful protest and the right to receive information, religious freedom, what course of action would you recommend for the preservation of those rights?
Well, I don't think people should be intimidated from exercising their rights. So I would tell students and others, if you feel that you want to protest. If you want to write blogs and letters, write them. I mean, that's part of what's great about our country, is we have the right to do these things, and we shouldn't fear retaliation or a retribution. So I would encourage folks to continue to, you know, freely exercise all the rights that we have. So.
Okay, next question is, to what extent do you think concerns relating to judicial activism and the separation of powers will influence judicial recognition or non-recognition of constitutional rights to civic education in both the federal and state courts in the long term? Are these concerns justiciable?
Well, I think, you know, as I pointed out in the opinion, it does matter who's on the Supreme Court. And so, and in that sense, elections matter. I mean, we had a very different court after Richard Nixon made 4 appointments to the Supreme Court than we did when Brown was decided under the Warren Court. And as time marches on, if history is any indicator, there will come a time when there will be a Democratic president, and there will be different appointees to the Supreme Court, and the court will look different than it is today. And that's one reason why I think it's really important that the court and I think the justices do feel this in spite of you know, all of the tumult, that you know, the court tries to make decisions that last, and that we don't just flip-flop. So I think that you know, there could come a time in the future where a different court might look at the Rodriguez decision and say that it was wrongly decided. That's obviously what this Supreme Court did in the Dobbs case when it overturned Roe versus Wade, and in the Loper-Bright case when it overturned the Chevron doctrine from the 1970s, and there are other examples. So, and there are more cases coming that are seeking to challenge decisions that have been around for decades, and so the court makes those changes, and so as the court changes, sometimes the law changes in these kind of big shifts. But ultimately, I don't think that's really healthy for the country, that the Supreme Court decision making is flipping and flopping, and so that's one reason why the states are such a great avenue for your plaintiffs, because they are sort of under-recognized, underrated historically as a vindicator of rights. You know, Justice Brennan, when he was on the Supreme Court, wrote a famous law review article imploring attorneys to go to the states, look to the state Supreme Courts. Nobody's going to the states. No one's looking at state constitutions and at state Supreme Courts. So I think what we're seeing now is another reason why this is such an interesting time in history. What we're seeing between the executive action that's going on and the composition of the Supreme Court, there's a kind of resurgence of our federalism in the United States. States are rising up, and both you know, in their political branches, but also their judiciaries, and reasserting some of these rights, and or in reasserting some of these policy positions that are maybe getting neglected by the new administration. So we're going to see a resurgence in federalism, which is really part of our system. So it's another aspect of that teachable moment.
Right. Well, thank you. You know, I'll just mention that it is interesting that the Kentucky Constitution and a decision of the Kentucky Supreme Court that we're relying on makes it clear that students have a very solid, positive right under the state constitution to an adequate and equitable education. And many other state constitutions have those strong rights. So we are going to pursue litigation in various state courts. But I kind of want to end this conversation and cite one other aspect of your decision, Judge, for the question of the relationship between the federal courts and the state courts on this question of civic education, kids' rights to a proper civic preparation. Even though the right is strong in the Kentucky Constitution and many states, people ask me, well, why'd you go into the federal court when you knew there was no clear right there? You were trying to push the court, push Judge Smith to drive that truck through the slight opening there. Well, the difference is we'd have to go into 49 other state courts to really try to establish this right throughout the country. If we could have gotten a decision in the federal courts and it was affirmed by the U.S. Supreme Court, it would apply to all 50 states. It would have had a catalytic effect throughout the country. And what I want to leave as my final comment and give you the opportunity for the last word if you want to say anything further after you hear what my point I'm making. What I teach to my students in law school about Judge Smith's decision in the Cook case is he not only said there was a crack and we were trying to drive a truck through it, but he kept that crack alive. That's the way I read your decision, because you referred to another decision that the Sixth Circuit actually had declared had to be considered not quotable, but you quoted it, saying that there was at least a slim right to a basic education, certainly reading and writing, basic literacy. But we were asking for a lot more, and we were in the Rhode Island case, and you weren't going to go that far. But you kept a flicker of a flame that there has to be some minimal right, and a future court could define possibly what it is. So I think you kept the possibility alive that there may be a Supreme Court someday that'll pick up where you left off and really enlarge this right to inspire a higher level of civic education throughout the country. That's my final statement, Judge Smith. I'll leave it to you if you want a last word beyond that.
Yeah, well, I mean, I agree that that Sixth Circuit opinion, which was nullified by the fact that they sua sponte, meaning the court without a motion decided to take it to the full Sixth Circuit, the en banc Sixth Circuit. So it made that decision a nullity, but it was a really scholarly and fascinating opinion, probably the best, I think, exposition out there about the need for that sort of basic literacy, basic level of education in order to be a functioning U.S. citizen. And that, I think, is the sort of the door that was left open by Rodriguez and other cases is the possibility that there's a floor that you can't fall below in terms of basic education that you need in order to be a functioning citizen in the United States. And so I agree that that door is still open. Maybe a court in the future will take it up. I mean, there's a lot way beyond the answer to this question, but there's a lot of argument to be made that we have a population. You cited at the very beginning the statistics. We have a population that maybe is functionally illiterate when it comes to civics, and that's a dangerous thing. So we might evolve to the point someday where the court does say, yeah, we need to do better in terms of just basic functional literacy on civics and what it means to to be able to participate in our democracy. One of the fascinating things, this is just sort of a historical but kind of interesting little data point and very relevant to what you're talking about today. But the Sixth Circuit, the chief judge of the Sixth Circuit is a guy named Jeffrey Sutton, and Jeff Sutton, who's actually here at this meeting. I'm going to I quote him in the opinion because he wrote a book called 51 Imperfect Solutions about state constitutions and vindication through litigation in state courts. And a lot of that book is about education. And he's written a subsequent volume since the opinion. So he was one of the people that was behind getting that Gary B case up and nullifying it, because I don't think he liked that that opinion. But if you read his books, he's a big advocate of state court, and particularly education cases in the state courts.
Okay, well, thank you so much, Judge Smith. This has been enlightening for me, and I gather from the comments in the chat, it's been enlightening for so many of those who have tuned in and watched us, and we really appreciate you taking the time today, and we appreciate all your taking the time to write such a towering opinion and inspire so many of us to go on pushing for more civic education. Thank you.
Well, it's been a pleasure to be here, Michael. Thanks very much for inviting me, and I appreciate all the interest there is with the audience, and so I'm glad to be a little bit of help.